Good morning. All right, good morning.
Good morning.
So today's time and date for hearing. Mr. Burns is now present, is that correct?
Yes.
All right, the record will reflect that. This is today's date and time for a hearing on a motion filed for sentence reduction or modification of sentence conditions. All right, Ms. Plummer, what would you like to say in support of your motion?
Your Honor, the goal of this motion, as I think is clear, is to aid in the reunification process, which I understand that plan should be finalized today at a later hearing. And so we've laid out two options in this motion about how to best do that in conjunction with the criminal sentence. The first being a sentence reduction pursuant to 801257. Now, in some ways, that's both the simplest path, and quite frankly, Mr. Burns is deserving of that, regardless. The statute notes that that should be given if the conduct, diligence, or general attitude of those inmates so suggest. Mr. Burns is a porter. He's earned trustee status. He's had no disciplinary incidents in the jail whatsoever. The state's main argument against that is that he has not expressed remorse. Of course, if remorse is equated to a admission of guilt, certainly that is true. Mr. Burns has always maintained his innocence from the get-go, and he continues to do so today. He has expressed remorse for what he has always said happened on that day, the day in question. There's nothing in the statute or the case law that includes a requirement that the defendant admit guilt in order to be entitled to this reduction. And it would be unfair to require that, particularly in a case where the defendant is pursuing an appeal at this moment, in part based on the sentence. Now, this option would have the added benefit of Mr. Burns being able to work and support his family, which is something that he is very eager to do. Now, if the court did not choose that option, the second alternative that we've laid out is a modification of the sentence conditions, primarily a form of day parole so that Mr. Burns could be released to attend counseling sessions that I believe are anticipated as part of this reunification process, the first being parenting sessions, the second being political therapy sessions. Now, MCL 801.25 permits the court to release an inmate for such a purpose, for mental health counseling, psychological counseling, and mental health treatment. Now, the jail can accommodate parenting sessions with Mr. Burns and the social worker, and after 6 weeks, should that be part of the plan. With Naomi, there was some question originally about whether they could accommodate that. They have told me now that they can. However, in our view, those sessions, particularly once Naomi is involved, would be better elsewhere outside of the jail. Dr. Kushler,
How's the jail indicated they're going to accommodate that?
They have said that they can arrange a contact visit, I imagine just in one of the attorney rooms where the three of them would be present. It would be a contact visit in the jail for an hour a week.
And how are they going to be providing some sort of deputy to be present for? I mean, how are they accommodating that? Because, or is the defendant paying for that, paying the jail for that? Because it's the court's understanding that they don't provide contact visits with children.
That, I believe, was...
So how is he getting the exception here?
I'm not quite sure, Your Honor, the answer to that question. That was my original understanding, too. I spoke with Under Sheriff Michael Murphy, and he told me that that was not a problem, that they could have the contact visit. He understood that after 6 weeks, Naomi Burns would be present at those sessions. I think perhaps the court is concerned, as is Mr. Burns, that those sessions would still be better held elsewhere rather than bringing the child into the jail. And perhaps, I'm not sure if it's considered an exception or if it's just a unique circumstance that has never happened before.
Oh, I got lots of dads that are on parent agency treatment plans over in that jail.
Sure.
They don't get that kind of treatment.
Right. I suppose I don't know the answer to that, but I was told that they would be willing to accommodate it.
Right.
Again, but those could happen elsewhere should the court structure an order that allows day parole for those hearings so that Mr. Burns could leave, some specified time before, 30 minutes or whatever, and then go to the session, come back. Dr. Kushler does not do therapy sessions at the jail, so day parole would be required for that regardless, so that Mr. Burns can start his individual therapy should that be part of the reunification plan. Just a few other housekeeping matters, other conditions of the sentence that probably would have to be modified in accordance with this reunification plan. There is a provision in Mr. Burns' probation that he not have contact with Naomi Burns. Obviously, if and when reunification begins, he's going to have contact with her, so that condition we would ask to be modified. Second, it's also my understanding that the court had previously stated at a prior hearing that the LaCasa program, completion of the LaCasa program, the battery program, would be removed as a condition of probation, as it is being replaced with other therapies. And finally, there's a question about, which may or may not be relevant, particularly at this time, depending on the court's ultimate decision, but whether probation can be modified to have Mr. Burns be permitted to travel outside of the state for work purposes, which he was allowed to do while on bond. There were no issues with that. And a related point, that the drug testing requirement be modified for those periods when he's out of state, such that he's not required to submit to random drug testing outside of Michigan. His airline does random drug testing regardless. So those are the two options that we have laid out and are asking the court to either reduce the sentence or modify the probation such that the reunification plan can proceed.
All right, I just have one other question.
Sure.
So with regard to 801-257, the statute outlines conduct, diligence, and general attitude. So what has Mr. Burns been doing that satisfies the elements of the statute? What's he been doing over there?
Sure. Mr. Burns has been participating in Bible study. He's not allowed to participate in the jail Bible study in person, but he receives documents from the chaplain and he participates in those. He is reading parenting books. He is serving as a porter in his unit.
Supporter.
He is
He's doing a
responsible
supporter.
for cleaning his unit, is my understanding.
Okay.
And has been, actively engaged with reading Bible study. And
Why isn't he allowed to attend the Bible study in person?
it has something to do with where he's housed in the jail. I believe he's housed in a different unit because he has to be active.
Oh, okay. And I'm sorry, you said porter and what else?
He's earned trustee status.
Oh, okay.
And he's also actively been reading parenting books to further his parenting skills.
Is he involved in any other programs over there?
He's not involved in any other programs. The only other programs that are offered to him is in the...
Is he doing MRT?
MRT, thank you for bringing that up, Your Honor. MRT is not, for one, is not something that Mr. Burns was aware of. It's not listed as a program offered in the inmate handbook, which I have a copy of. Moreover, my understanding and Mr. Burns' understanding of the MRT program is that this is a program where inmates discuss their crimes and are encouraged or required to admit their guilt, which again is not practical for Mr. Burns to do because he has always maintained his innocence and he is pursuing an appeal based on that. And so, frankly, it would be my advice to not participate in that program.
What's he been doing as a trustee? You said he's got trustee status, so what's he been doing?
I'm not quite sure exactly what that entails, Your Honor. It's something that's granted to inmates when they have good behavior and result in an additional reduction of their sentence.
Right. So other than the 1 day for every 6 days, what's he getting as a trustee?
30 days.
Just an additional blanket 30 days once you hit trustee status?
Yes.
Okay. But he's not doing any additional activities, duties, anything like that as a trustee?
If I could just have a moment, I will.
Sure.
As part of the trustee status, he also works in commissary services, fulfilling orders and requests from inmates. That's a 1 day a week.
Okay. Do you have anything from the jail to support the argument that he's met those elements? Do you have any letters, anything from the people who run those programs, anything like that, in support of his character diligence or?
We do have certificates of completion of his Bible study participation, if the court is interested in seeing those. From the jail, I have nothing specifically. The trustee status is essentially a symbol of that. That's not something that would be granted to an inmate should he not be deserting, should he not be.
Do you have verification of it? Anything in writing? Anything to attach or support with regards to that?
I don't have anything in writing, but I don't believe that's up for dispute in their response. I believe the prosecution has agreed that he has earned trustee status, so that's not a disputed point.
All right.
I don't have.
Okay.
Thank you.
All right. Mr. Rose, any response?
Yes, thank you, Your Honor. The people's position that granting this motion would be ill-advised in both the public good and public safety. And I have a number of reasons to support my advocacy for that conclusion, and I hope you find merit in those reasons. The defendant makes a request for 6 different areas of relief. He asks for a 25% reduction pursuant to 801.257. And then he has, following that, 5 different terms of probation he is asking you to modify. Release from jail to attend counseling under the equivalent of what would be a work release. Permit out-of-state travel. Discontinue drug and alcohol testing. Permit contact with Naomi Burns. And remove the batterers counseling at La Casa as a term of probation. Now, the defendant offers 2 legal bases for these claims of relief. The first one, the 25% reduction. The court's familiar with the statute. And as counsel noted in their brief, and we did in ours, there's one case in Michigan, People v. Roth, that has interpreted that statute. There's a very important provision at page 730 of that case that goes into a description about the application of the statute. And I think there's a point in that case that's important to apply here. And in reading that case, I think we must all agree that the defendant's request for this 25% reduction is a matter of pure equity, solely within the sound discretion of the sentencing judge, and not a matter of law to which he is entitled to that reduction of sentence. The defendant may only successfully challenge this court's ruling on this motion if he can show that you exercised an abuse of discretion in your ruling. So I think it's very important to start out this hearing with the understanding that this is really a matter of near pure discretion by Your Honor, of course limited by the bounds of whether you act under an abuse of discretion. The other 5 factors that the defendant requests are really the only legal support I could find are in paragraph 13 of the original motion, in which the defendant states, and this is directly from her pleadings, further, it is within the inherent authority of the court to authorize specific terms and conditions of the sentence imposed upon Mr. Burns. No authority cited. And counsel may have misspoken her oral argument before you when you pressed her on the issue of where do you find support for me to make all of these orders, such as day parole, to attend counseling, to allow visits with the child in the jail. And counsel cited MCL 801.25, and I don't know if she truncated the last, so I looked up 801.25 while she was arguing. That's a statute that actually deals with how long a jail may impose solitary confinement in bread and water upon a prisoner. I don't think that applies. So I was led to conclude that perhaps she misstated the statute she was relying on, because I looked throughout the briefs that were filed with this court to answer that question. And I think they're wrong on that point. There is no inherent power that this court has, and it begins with Article 3, Section 2 of the Michigan Constitution, which is the basic separation of powers that this court has with other branches of government. And it is also, I think it applies MCL 51.75, which is the unique power that the sheriff has over the charge and custody of the jail. The court must keep in mind that the sheriff has the ultimate responsibility over prisoners, and if this court enters an order that compromises that basic authority of the sheriff. And a good example is the work release program, most commonly discussed in this court. If there is no program and the sheriff is not taking responsibility to place prisoners under his control in the community, this court cannot force that. That's the corollary to the unique request that's made in this case to have a 20-month-old child brought into the jail setting for visits with the defendant, leaving the sheriff in the position of having to ensure a prisoner that you've sent there to take responsibility for this unique circumstance. Day parole for counseling is another example. And the question becomes, does the sheriff have such a program and willing to take on that responsibility? So I go back to paragraph 13 of their motion. The claim that you have inherent authority in it goes so broadly as to encompass the relief requested is really not supported in law, and at its fundamental level is a conflict with the separation of powers. So, looking at this motion, I question the applicability of 801-257 on a couple of reasons. This court ordered a probationary sentence. You have the authority at any time on a probationary sentence to modify the terms of that sentence. In addition, the question for me, when a court is given equitable discretion, such as you're given under 801.257, where do we look in the law for boundaries on the exercise of that discretion? What gives a judge parameters to look at in deciding how should I handle a motion such as this? And so what I did is I went back to MCL 771.1, and it provides a very good reminder, because so often in this court, probation is just considered as something that's going to be granted. But we should really go back and look, what did the legislature say in the statute about granting probation? Because it does give you the parameters to look at when is it appropriate. And there's three criteria, and I'm reading from the statute itself. First is if a defendant has been found guilty upon verdict or plea. That's the easy one. 2 and 3 make it a little more difficult. Secondly, and the court determines that the defendant is not likely to engage in an offensive or criminal course of conduct. So when we look at probationers, there's an assessment, is this conduct that's likely to repeat or not? And the third criteria for granting probation, and that the public good does not require that the defendant suffer the penalty imposed by law, and the court may place the defendant on probation under the charge and control of a probation officer. So there's a public good aspect to probation as well. The statute asks the court to stand in the shoes of the public and look at the crime that was committed, because that last provision is a consequences portion of the statute and asks for a balance. And so you have the ability under 771.1 at any time to modify this sentence if you think it's appropriate after imposing. You're not constricted by 801.257 to a 25% reduction. You could let this man go today if you felt it was appropriate. I would suggest to the court that would not be advisable in looking at his request for relief. And this court has before it material that was attached to the defendant's motion that really nobody else has access to or knows in this case about the defendant. The defense attached the psychological evaluation of Dr. Charlene Kushler. And I must give credit to Dr. Kushler because she used 3 intensive psychological tests, each designed to evaluate a different aspect of the defendant's psychological profile in order to make an assessment of any personality concerns the defendant may present and what should be done to address those concerns. Now, Dr. Kushler didn't just interview the defendant and through interpersonal reaction or interpersonal interaction attempt to draw conclusions that could have a profound effect on the safety of his daughter. Rather, what she did was she used professional tools accepted in her field, to draw information in an objective manner, to reach her conclusions about the defendant. And having read the report that you have attached to the motion that was provided by the defense, this is not something that the prosecutor responded with. I don't know why the defense would attach those results of his psychological profile when bringing a motion that asks for you to act in equity and use your judgment as to whether or not he should be released. Now, those tests objectively measured three aspects of the defendant. First, and I'm going to kind of sum this up, the first test was his straightforwardness versus his presenting a front. In other words, is he genuine in the representations he makes in his approach to information? Second test, and these are all the objective tests, was personality functioning test. And the third test was designed to measure his parenting skills. Now, there's some very interesting things she said about the defendant from these tests, and by the way, they were objectively measured, and I'll go through, because she put it in her report, this information. The first test, and it's important in looking at this, was the Millen Clinical Multi-Axial Inventory, otherwise known as the MCMI. And that test is interesting because compare what conclusions I'm about to describe that she drew about the way the defendant psychologically presents to what he presented to the police and the court and the jury in this case, and the conclusions that each drew. The test describes the defendant as a person who is engaged in, quote, denial of emotional problems, who has resistance, and by the way, these are quotes I'm using from her report. This is not my words. Person who engages in resistance to admitting psychological problems, downplaying behavior that would evoke ridicule, may sometimes experience oppositional, if not cynical feelings. He hesitates expressing them for fear of losing emotional control. She described him as having, quote, hidden feelings with periodic surges of resentment that may break through. Quote, Joshua's defenses are well constructed and general insight is likely to be temporary at best. Joshua appears reluctant to share on an emotional level, maintaining control wherever possible. Quote, he may prove reluctant to convey even factual information, preferring to deny difficulties. I'd hark the court back to the pre-sentence report and his response to any issue of how you might go to treatment to deal with alcoholism. This is probably the most disturbing quote in the entire report at the end. The MCMI indicated that Joshua presented as having obsessive-compulsive and histrionic personality traits and narcissistic and antisocial personality features. Now, the court, in your work on the probate side, knows the meaning of those diagnoses. These are not casual findings that this test made regarding his personality. Narcissistic, focused on himself. Personality disorders, that's a very difficult, and you've heard the psychologists talk about that being one of the most difficult psychological problems for them to deal with because of the focus and the presentation. And so I'd ask the court to think about what this objective test revealed in comparison to what two juries found in terms of his presentation and whether he was believable and truthful. Now, the Rorschach test was the second one, and that measured his personality functioning. And that was a test that was scored, by the way, by computer for objectivity purposes. This wasn't just a test that Dr. Kushler decided to score on her own. Here's what it said, quote, he appears much less willing than most people to process emotions. His responses reflect that he is exerting more stringent control over his feelings than most adults. This emotional inhibition may place him at risk for adjustment difficulties in interpersonal relationships. Joshua appears to possess inadequate social skills. His responses reflect less interest in other people than most people possess and limited capacity to form close relationships. Joshua is likely to have little tolerance for uncertainty and ambiguity. He has simplistic problem solving that may result in Joshua failing to recognize the kind of behaviors that are expected or required in various situations, which will in turn put him at risk for behaving in ways that offend others or get him into trouble. And basically what this describes is a person, I would suggest, not equipped to handle the challenges of caring for a 5-month-old baby, who is and this is a person who is at higher risk for behaving wrongly when a 5-month-old presents those challenges, which is the case we have here. And the last test was the Brooklyn Paths test that looked at his parenting strengths and weaknesses. And what that test concluded was that he presented weak areas in sensitivity to the child, empathy. And compare that to the first test that showed him to be narcissistic and have a personality disorder. Because those are two personality disorders that don't equip a person with the skills to be sensitive to a child or empathetic. So, you compare this to what we know in this case. You go back to March 18th of 2014 when a 5-month-old showed up at the University of Michigan Hospital with 4 things: low blood pressure, seizures, episodes of non-breathing, and injuries that the treating physician said were consistent with physical abuse. Lengthy investigation, police and medical providers both looked into this. The defendant was allowed to tell his side of the story, and what it revealed was that this child had a traumatic event. That's what brought these injuries to the emergency room. And that these injuries occurred while under the care of the defendant, her father. He was allowed to explain, and he tried to explain the incident as an accident. His explanation was inconsistent with the injuries the child suffered, and the injuries reflected intentional violence and not an accident. So now you had 2 juries, one comprising of 12 people under the highest burden of proof in American jurisprudence, and the other comprised of 6 people under the second highest burden of proof, presided over by Your Honor, who let the defendant tell his side of the story, as he has a constitutional right to do, and you did not allow the prosecution to present irresponsible evidence in support of its claims. Now, these 2 juries each listened independently to both sides of what was presented and carefully considered what each side had to say and found that the defendant did not tell the truth. And how does that compare to this psychological profile that they had no access to, these objective tests that they had no way of knowing? But you do have that information. And what both juries found is that these horrible acts of violence committed towards this 5-month-old were committed by the defendant. So now in his motion, we get this psychological profile that the test revealed. He denies emotional problems, he downplays his behavior, he has fear of losing emotional control, shows little personal insight, processes emotions poorly, possesses inadequate social skills, as a parent lacks sensitivity and empathy for his daughter, is described as having tendencies that are consistent with being narcissistic and antisocial, and which puts him at risk for behaving in ways that will get him in trouble. Those aren't my words. Those are the report that the defense submitted from the psychological assessment of who he is. And so now this man wants out of jail early. He wants no batterers counseling, but wants to be back with his daughter, who is now 20 months old, that he was found by 2 juries as being responsible for inflicting life-threatening injuries upon him. So, in your exercise of discretion, I'm asking you to consider 2 areas in deciding whether or not this is prudent to grant the request that's being made by the defense today. First area I'd ask you to look at is the 4 sentencing factors that go into every sentence. And I would suggest that of the 4, they play a different weight depending on the crime that is being sentenced for. In a crime of violence, such as this, I would suggest that protection of the public is paramount over the other three. In this case, without, and by the way, this court deals often with crimes of a nature that require insight as the protection that society is looking for in reformation. And there's good examples of that. You get drunk drivers through here who are in their third, fourth, fifth, we had them up well into the double digits. And what the court is looking for is some insight. Do you finally get it? Are you going to understand your problem and deal with it? And then we offer to those people the tools to help achieve that goal. You get domestic violence people through here in many forms. Criminal sexual conduct. And the court's looking for the same answer. Is there some insight into what brings you before the court? And if there is, we will provide to you the tools to accomplish that. So in evaluating whether the public is going to be protected by you granting this reduction under what I've just presented to you as their information about their client and what you know about the conduct of this trial and how those two compare, I don't care whether he admits his guilt or not. I don't want to get into that legal quagmire of an argument. At a basic level, is there something in this case that shows insight that will provide protection to this now 20-month-old? And the second comes in the question of 771.1 that I first described. Because you go back to look at not likely to engage in an offensive or criminal course of conduct. What do we have to hang our hat on in this case to say that the injuries inflicted when Naomi was 5 months old will not be repeated? And secondly, the question of the public good does not require that the defendant suffer the penalty imposed by law. That's the legislature's words, not mine. So when we as a public look at this type of crime, what degree of culpability, what degree of consequences do we attach to that? And is the public good served by granting the reduction that the defendant requests? I asked it, and I said early on that I hope you find merit in the argument that I make, but I would suggest to the court, with all the information that you possess in this case, the answer to those questions would be no. And I'd ask the court to deny the motion.
All right, Ms. Plummer, any response?
Yes, Your Honor. I would start by, perhaps I did stating that I did misspeak when I cited the statute that gives the court permission to grant day parole. That is 801.251, which clearly gives the court authority to grant day parole for this purpose. It says, quote, the court may grant the person the privilege of leaving the jail during necessary and reasonable hours for any of the following purposes. It lists several purposes. Subsection E is medical treatment, substance abuse treatment, mental health counseling, or psychological counseling. So that is clearly within the court's authority to do so. It's in the statute. It's been granted to the court by the legislature.
Does the Livingston County Jail have a day parole program?
Yes, the sheriff was the one that mentioned the concept of day parole to me. He said that we can release people on day parole. They have done it before. And so this is something that is within their capabilities to do. And I don't think we see that unusual. And it's very similar to work release, which, again, the jail is familiar with.
I am familiar with the work release, but the court's understanding is that the Livingston County Jail doesn't do work release any longer because of the changes in the statute, which put the onus on the jail to supervise these people when they're out in the community, which I've been told the Livingston County Jail does not have the resources or the manpower to do. So what they've eliminated the work release program on that basis. So is that what you were told?
No, I was told that day parole, if the court structure is in order, such allowing day parole is permissible. I was told either that the sheriff has to be paid, they have to pay overtime for someone to transport the defendant at $60 an hour, which would be the defendant's Mr. Burns' responsibility, or Mr. Burns can have transportation arranged elsewhere. So that was clear. My clear understanding was that paper is permissible, that they can do this, they have the ability to do it. He was, Under Sheriff Murphy was the one who presented that as
Oh, so they're willing to do it for a fee.
yes.
The defendant has to pay for the supervision
Yes,
while
okay,
he's
but-
outside of the jail.
My understanding is that either he has to pay for the transport or he can arrange his own transport.
And they're just going to let people walk out with day parole or work release, just let them walk out of the jail if they have their own ride.
That is my understanding, yes. And I believe other counties have work release. I realize it's not in other counties, it's Livingston County, but have work release programs where that is the situation where defendants leave and they're required to come back. Obviously, if they don't come back at the time that they're required to,
Because my understanding of the statute is that, at least with regard to work release, is, and what I've been told, my understanding is that those are used somewhat interchangeably. Day parole, work release, it's the same.
yes,
The end result is they get to walk out, go to work, go to therapy, go to substance use treatment, whatever, and then they come back at a certain time. But my understanding of the change in the statute is that the statute requires that they be supervised by someone from the jail. And what you're telling me is that the jail has told you that they're willing to do that at $60 an hour.
yes. And if that were, preferable to Mr. Burns arranging his own transportation, that would be fine. The idea here is for him to get out to go to the therapy. It has to be with the sheriff's office for $60 an hour. I think that is perfectly fine and reasonable. And then again, I would, in terms of the court's authority to do all of these things that we've requested, I would again cite, which the prosecution has cited themselves, MCL 771.2, which clearly says that this court has the authority to modify probation terms as that's all we're asking for the court to use its authority fairly granted under the statute to modify it. Now, I agree that perhaps 801.257 is actually not necessary because this is just, the jail sentence is merely a provision of probation, which can be modified under 771.2 at any time. Either way, I think the court has authority to do it under either one of those statutes to reduce the sentence. Which one we use, I don't think really matters. As for the extensive discussion of the psychological testing, I think the court is familiar with all of that. The court has considered all of that in prior testimony. And Dr. Kushler's ultimate recommendation in that report is that he has no major psychological problems. He can be treated. She has made these two recommendations. All we're asking is that he be permitted to go forward with those recommendations that she has given. Now, there was also some discussion of the facts of the case, and I don't think we're here to retrial those issues. Yes, there was a jury verdict. That jury verdict was on appeal. We're not asking to rehash the jury verdict right now. We're asking to modify the sentence or the terms. As for the batterer's class, that was something I was not present at that hearing, but I understand that the court had brought that up to the Sante that the batterer's class could be removed as a condition of probation, given the other recommendations for therapy. Unless there are other questions about this.
All right, I just want to confirm, and 801.257 also requires so long as the defendant has reimbursed the county for expenses incurred in order to conditions of probation. So you paid off all the financial assessments that were ordered?
One moment, Your Honor. Those have not been paid, but Your Honor, the defendant, Mr. Burns, can pay those this week.
All right. Anything else? Okay. So, thank Thank you. So with regards to MCL 771.2, the court may amend the order of probation in form or substance at any time. With regards to the reliance on that statute for a reduction in the jail, this is the court's position. Absent something compelling, when the court hands a sentence at the time of sentencing, it needs to have meaning, and this court's sentencings do mean something. I don't find anything compelling present here that would make this court make any modification of the court's original sentence. Moving to 801.257, that does provide the court with the discretion to reduce a sentence. The language is very specific for that prisoner's good conduct, diligence, and general attitude. Such a reduction is subject to the defendant reimbursing the county for expenses incurred in order to the condition of probation. So really, when I look at this, I want to look and see, make sure that people have paid everything before probably they even walk in here asking for the court to use that kind of discretion. Secondly, this is a difficult statute because there isn't a lot of case law out there providing the court with any guidance as to what is good conduct, diligence, and general attitude. The statute really leaves it to each individual court's interpretation and discretion. When I look at this statute and I look at good conduct, diligence, and general attitude, I want to see that jailers or prisoners are going above and beyond. Of course they should have good behavior over there. Absolutely. They should be demonstrating skills that are productive and appropriate for release to the community. Are they just sitting biding their time, reading books, or are they going above and beyond with diligence in their good conduct and general attitude? And really, what's before the court is there's really nothing before the court to demonstrate or support that. There's nothing for this court to rely on other than the defendant's own self-serving statements that he's, has a good attitude. I recognize that he's been granted porter and trustee status, but there's nothing provided to the court as to what people have to do in the jail to even earn those status. Do they have to exemplify, good attitudes, work ethic? The court needs something more than just a blanket general statement that the defendant has demonstrated diligence, good conduct, and general attitude. I don't think the defendant's met the burden. I want to see, it's not that I wouldn't consider his motion. I have considered it. I just don't find that he's brought anything in support of his motion to demonstrate to the court that he's met what I think the statute requires. What does he do? It's still really not clear to me. What are his duties as a porter? How did he earn trustee status? What did he do? Something, even a letter of some type from, any of the sergeants over there or any of the people that run the programs. I know the jail offers quite a few programs, and I don't have anything in front of this court for me to make any findings with regards to that. So I'm going to deny your motion. I'll deny it without prejudice. If you want to come back with more support, I'd be happy to look at it. But based on what's before the court today, I'm going to deny that motion. With regards to the other miscellaneous motions to modify the conditions of the probation, I will indicate at this time that I will grant the motion with respect to lift the no contact provision of his probation. No contact shall be lifted only with respect to the minor child Naomi and only in compliance with NA orders. So I will modify the order of probation to be consistent with whatever orders get put into place in the child protective proceeding. I will indicate that the probation agent has the discretion to approve out-of-state travel. I'll give the agent the discretion to do that only for employment purposes, so long as proof of employment requiring out-of-state travel is provided. So if Mr. Burns can provide that to his agent can approve whatever out-of-state travel is required for his employment. As far as the drug and alcohol testing, I will give the agent the discretion to test for both drugs and alcohol. I'm not going to put a blanket order in place that simply states there'll be no testing while he's traveling. I don't think that would be prudent or appropriate, but I'll give the agent the authority and discretion to test whenever they think it's appropriate. I will, based on the evidence presented to this court in the child protective proceeding, I believe it was from the recommendation of Dr. Kushler based on her extensive testing, I am going to rescind the order for the DAIP program. It was Dr. Kushler's recommendation based on her testing that DBT therapy was more appropriate for this defendant. So I'm going to rescind the order for DAIP, add an order for DBT therapy 26 with, for a period of no less than 26 weeks with a qualified clinician who is trained and certified in providing that therapy. It's very specific.
Could you say that again? I just want to get
Minimum of 26 weeks with a qualified clinician who is trained and certified in DBT therapy. It's very specific. It has very specific training. And I think through the NA case, I think the Department of Human Services, Health and Human Services works with a couple different clinicians that have that, that training. So that shouldn't be a problem. I think that covers it. Did I miss any of the other?
work release type counseling?
Oh. So again, I would say it's not real clear to me what the jail programs are. I suppose if they are still running some type of work release program, I'd like to see what that is. I don't know why. Are you being told that that requires a court order?
Yes, that's my understanding. Is that they would need a court order to release him for a day parole. Yes. If it's helpful, Judge, I could reach out to them again and ask it for clarification, just to address court concerns about the statute before we submit that part of the order.
Okay. I think that would probably be helpful, because what my understanding of what the jail provides and no longer provides sounds to be in conflict or contradiction with what you are being told. And maybe they've changed some of the programs and they've brought back some of the programs and I'm just not aware of it. But that may be helpful. I'm not going to rule with respect to any work release or day parole until I am provided with something that outlines what is available for defendants to be able to be released for work or other types of programs.
But how do you want us to handle that portion, since it's kind of got an unknown fact?
You know, again, I think that what probably I can deny it at this time without prejudice. If you want to rebring them, reprecipitate the motion with respect to what specifically you're asking of in the order from the court. I mean, is he just asking to go to his individual therapy? With who? How often? I think that has to all be outlined in the order anyway. At whose expense? I'd be really surprised if they would just allow a defendant just to provide his own rides, because my understanding of the statute is that the jail is no longer allowed to do that. Mr. Rhodes, have you been provided any other information with regards to the programs available at the jail?
My information is only limited to the quick release, so I really don't know.
Okay.
I'm happy to do that, Judge. I will get clarification on these questions and the issue.
All right.
We might not have this order ready today. You mind if we confer? Hopefully we can agree upon the language and submit it to the firm.
Sure. Does Dodie Viola, is she go to the jail? I think you mentioned Dr. Kushler, but what about Dodie Viola? Is she willing to go to the jail
She is, Your Honor.
to begin that type of therapy
She is.
with regards to the reunification process?
Yes,
She's willing to do that within the jail setting.
yes.
All right. You don't need any type of order for that.
I don't believe so.
So what you're talking about is might be counseling with Dr. Kushler or a DBT therapist, or is Dr. Kushler the DBT therapist?
Dr. Wardman do DBT therapy.
Okay.
She will come into the jail.
Okay, so that can begin within the jail.
Sure.
So what does he need to go out of the jail for?
Dr. Kushler needs to leave the jail.
Oh.
And also, after 6 weeks, with the parenting sessions with Dodie Viola, my understanding is that Naomi Burns is supposed to be integrated into the session, so there's some question about whether it would be preferable for those to occur outside of the jail for the benefit of Naomi.
Would Dodie Viola recommend reunification beginning in a jail setting?
I don't know. I have not asked, Your Honor.
Has she started coming there? Has that therapy started?
No.
All right. So we're at least 6 weeks away from that,
Yes.
even if she were to start this week or next week.
Correct.
Okay. Okay.
Thank you.
Thank you, Your Honor.
Thank you.
Calling the matter of Naomi Burns, case number 14708NA.
All right, good morning. Appearances, please.
Good morning, Your Honor. Michael Concrete appearing with on behalf of Joshua Burns.
Joe Aldridge representing the Department of Human Services.
Good morning, Your Honor. Alexander Garkoff, OGAL.
Actually, Your Honor, that's the Department of Health and Human Services.
Great. All right. Good morning. So today's time and date for continued disposition in this matter. Let's go ahead and look at have the parties received. We'll go through the documents, make sure everybody's got copies, and have them marked for purposes of today's hearing. All right. So what I have received is, and I think one report here might be old. So I'll just go through and indicate to the court what I have. I've reserved a Michigan Department of Health and Human Services case service plan, which also contains attached to it a parent agency treatment plan. And that report is dated August 24th, 2015 for the period of June 23rd, 2015 through August 27th, 2015. I'll mark that as Exhibit 1. Then the court has also received another case service plan from the Department of Health and Human Services that also contains a this one also contained parent agency treatment plan. Is it not? Maybe
What's the
this
date of
is,
that report, Your Honor?
this one is for September 24th, 2000. Oh, this is the old one.
Yes, ma'am.
This one's dated September 24th, 2014. I don't think it contained a parent agency treatment plan. No, 'cause it was old.
Our
Okay.
position would be that report is stale and not relevant at this time.
Dated, are the parties, is there any objection? Are you asking that it not be marked or admitted today?
Yes, ma'am.
Okay, any objection?
No objection.
Okay. So then I also have one more recent than that, but may also be dated. I have a case service plan for the report date of March 30th, 2015. This is for the report period of January 6th, 2015 through March 30th. I don't know if this one... These just get submitted periodically, so I don't know if this one also is outdated. And if,
Would be really that one's also.
okay. So you're not asking that this one be marked or admitted today?
No, ma'am.
Any objection?
No objection.
Okay, so just so that there's clarity, we'll just, that leaves only this case service plan with the report date of August 24th, 2015. And everybody's got this report?
Did the court have two parent agency treatment plans attached to that, Your Honor?
I have a parent agency treatment plan
One for,
prepared for Mr. Burns.
There's also one, I believe, attached for Mrs. Burns.
Okay. Yes, there is one prepared, parent agency treatment plan prepared for Brenda Jean Burns, the non-respondent mother. So, has everyone received that? It should be attached with it.
We have it.
All right, and Mrs. Burns, I noticed that Ms. Warner is not here. I just realized that. Is she going to be appearing today?
Your Honor, I'm not sure where she is. I guess I'll be.
For the benefit of the court, I made 2 attempts to reach her on her cell phone. I got voicemail both times. I sent her a text asking her if she was en route, got no response. So I don't know.
Okay. I think I recall when we scheduled this date, she checked her calendar.
So on the record that she was here.
And she indicated that she didn't have a conflict with today's date, which I would interpret to mean that she intended to be here. So I don't know, Ms. Burns, how do you want to proceed? Are you asking for an adjournment to have Ms. Warner present? Are you waiving her appearing with an attorney?
I will
It's up to you.
I will wait.
Okay. Are you sure you want to do that? Because I know I had indicated at the last hearing, because you are a non-respondent, you have been adjudicated by a jury to be fit. I was going to ask you to essentially consent to, because you, by law, the court can't require you to participate and can't order you to do the services that might be recommended here, and that it would have to be essentially agreeing, consenting to do them, and to comply with the orders.
Your Honor, I will waive my right to consent to orders, and I will come back.
Okay. Are you sure you want to do that? I would consider giving you an adjournment. If you wanted the benefit of counsel present. Basically, it looks like what you're going to be required to do is essentially make Naomi, bring Naomi to counseling. Let's see. Work with DHHS in order to have the family reunified. I don't know if there's anything else specifically.
Your Honor, I've had an opportunity to read it.
Have you received a copy of this? And have you read it?
I was able to read it today, and I'm okay with those things, and will comply with them.
Okay. All right.
Your Honor, I believe there's a requirement that she facilitate parenting time when that becomes available. And Exhibit 1 indicates that Ms. Warner was present when this document was reviewed. Ms. Burns, is that correct? It was provided to Ms. Warner as well.
Okay. All right. Well, I guess we'll go forward then. If you're sure you're comfortable with that.
Yes, Your Honor.
Okay. All right. Okay, so this is, I'm going to go ahead and, now that we've clarified which of these three record. Oh, is she on her way here? Is she late? Has she been in an accident or something like that? Something happened?
She's not on her way.
She's not on her way. Oh. Is she indicating that?
Do you want me to have her transferred in here?
I'm being informed that Ms. Warner is on the phone with juvenile court staff. Indicating she had a death in the family?
Oh, yeah, hopefully she called her on there. She did not call here, so we made contact with her. She had a death in the family that we got about 3 times ago. Do you want her to transfer in and get her on the phone?
Is there any objection to Ms. Warner appearing by phone? Apparently she's available by phone.
No objection.
Is she asking
Your Honor,
for
the
treatment?
only objection I have is I have to be in Kalamazoo at 1:30.
Yeah.
I have a 2-hour drive ahead of me, so we're going to have to by phone to get her on the phone. Let's do it. Otherwise, we'll just adjourn the matter and come back another day.
Right. Ask her if she's asking for an adjournment. Because I'm not inclined to have her appear by phone.
She's asking to be on the phone. She's not asking either.
All right, go ahead, put her on the phone. All right, Ms. Warner, are you there?
Yes, Your Honor, I apologize. I feel I owe you an explanation. We had a death of a young mother in our family 2 weeks ago, and the family court's given us relative placement. And I have just not answered any emails or business stuff, and I forgot about it.
All right, are you, well, Ms. Warner, are you requesting to adjourn today's hearing to be present?
No.
All right.
My client and I have thoroughly got this additional action. We're ready to go.
All right. All right, and I've already, Mrs. Burns is present here today, and I've inquired if she's requesting an adjournment or is comfortable going forward. She's already indicated to the court at this time that she's reviewed and read the parent agency treatment plan. She is comfortable going forward at this time. And has placed on the record that she has essentially consents to the portions of the agency treatment plan, parent agency treatment plan that will require her participation.
Yes.
Okay. All right, so I've already marked the case service plan dated August 24, 2015 as Exhibit 1. I'm going to mark the parent agency treatment plan with regards dated August 24, 2015 regarding Joshua Quincy Burns as Exhibit 2, and the parent agency treatment plan prepared for non-respondent mother, Mrs. Burns, as Exhibit 3. All right, parties received copies of proposed exhibits 1 through 3.
Yes.
Any objection to admitting them today?
No objection, no. No objection.
Not for the mother.
All right, do the parties wish to take any testimony today?
No, Your Honor.
I don't require any testimony, Your Honor.
Okay. Let me go ahead and hear from Mr. Gartoff regarding his statutory duty.
Thank you, Your Honor. I was able to visit Naomi in the home on the 20th of August. She's doing well. Conversations with Mrs. Burns verifies that. Also examining well-child visit notes that Naomi had taken by Mrs. Burns. went well for her. During the visit, I observed Naomi moving about the house, playing with toys, demonstrating some fine motor skills. When she slipped and fell, she went to her mother for comfort. She has plenty of space to play. She has her own room now. She's no longer sharing a room with parents. All of her
Did you say you visit her in the home?
Yes.
Where she's living? Okay, great. Okay.
She was able to use some sign language to express some of her wants and needs, and she was also incorporating some words. All her needs appear to be being met, and she appears to be doing very well.
All right. Do you have any issues or any recommendations, any objections with regards to the parent agency treatment plan, or anything that needs to be addressed for Naomi within those agency treatment plans?
The only things that I wanted to address, Your Honor, was that Dr. Kushler's report, and I think this was already spoken about during the criminal proceeding, was that therapy should begin for approximately 6 weeks before integrating Naomi into staff, and that be adopted. Also, Dr. Hagen recommended that a safety plan be drafted and implemented. I asked that be done. Also, as the recommendation, substance use assessment be incorporated into the parent agency treatment plan, as well as provide for employment, sign all necessary releases, close with probation, which I believe this court's already ordered, as well as any service providers, and that the department be informed of any out-of-state travel, as well as any drug screens that Mr. Burns partakes in on the criminal side.
Brian, this is Mrs. Porter. Just to clarify the out-of-state travel, that would be out-of-state travel of who? Parents or the child?
Well, I was speaking specifically about the responding father. I know Ms. Warner didn't have the privilege to hear the court's orders in the previous case. But if Mr. Burns travels out of state for work, that information be provided to the department. If the child is going to be for an extended period of time out of state, like this happened previously, that I be notified and the department be notified.
All right. Any objection to that?
No, Your Honor.
No objection from the mother about her and the child's out-of-state travel.
Okay. Okay.
Thank you, Your Honor.
Thank you. And I can't find my notes from the last hearing. Could you remind me, Mr. Gartoff, what it was with regards to the substance abuse assessment? Was that done? Can't find my notes.
There was an assessment, I believe it was November of 2014, a key development.
Right.
Essentially, what it said was Mr. Burns was in remission, and that there would be random drug screens, and then if he was to fail screen, that he would be involved in outpatient therapy.
Okay.
And that's just from my recollection. Double check it.
All right, thank you. All right, anything else from the department? Any updates, corrections, deletions with regards to the report?
Yeah, he feels pretty good about how things are going. We're still a little confused about how the parenting time is going to be arranged, and require some direction on that.
Okay.
Given the policy situation of the department, they would ask that the court order the department to pay for the individual EDT and family counseling. They have to pay for it, they will require a court order.
Okay.
Mr. Wells indicated that Ms. Wood will be doing the independent and the DBT counseling, and she will go to the jail, and Ms. Viola will be doing the family counseling, and she will go to the jail as well, I believe. So I believe the only concern, there was a very good meeting with Mr. Burns. I think there was a very good meeting with Ms. Burns, Mrs. Burns, and the only real
Mr. Cronkite, anything that you want to add on behalf of your client?
A couple of things, Your Honor. I am looking at, in the first instance, I'm looking at exhibit number 3, which is Ms. Burns' parent agency treatment plan, and I'm looking at page 3 under action steps all the way at the bottom, where it says that Mrs. Burns and Naomi will participate in weekly therapy sessions with Dodi Viola. I actually don't know. I have never heard that that's part of the normal reunification therapy process, and it might just be that I haven't worked with her on the process like this before, but it at least suggests a concern for finding a way to facilitate this if there's one more person that's going to be present. In other words, I am not sure what's envisioned. This seems to be different than anything that I've heard from Ms. Viola, but if both Mr. and Mrs. Burns and then Naomi and then Dodi Viola were going to be accommodated in the jail, then I don't know if that changes any of the discussions that any of the counsel has had with the jail. Sounds like a wonderful idea to me, truthfully, so I'm not necessarily objecting to it, but somehow this needs to be at the guidance of Ms. Viola, who has a process that she goes through, and I apologize that I didn't inquire specifically what she would envision as Ms. Burns' role, but I don't want to put ourselves in a place where this is incorporated as an order of the court, and then we find out that that's not how Ms. Viola goes about it, and maybe the court knows more about that than I do. So that was the first thing that I wanted to raise, is that it raises more questions for me that I can't answer, unfortunately, as we're trying to figure out how to accommodate parenting time. I don't know if the department has any insight into that or not. So I may have to defer to anybody here in the courtroom who knows the answer to my question as to what the normal process is with Ms. Viola, whether the mother would be a part of that or not. But I don't know how many people we can get into the jail in a group therapy reunification session.
Well, I think I'm just going from my memory, but if I recall Dodi Viola's testimony, and maybe I'm mixing cases up, something to the effect of meeting with Mom, meeting with Naomi, getting to know Naomi, building some trust and rapport with Naomi, while simultaneously meeting alone with Dad until they come to a point where those paths it would be recommended to merge those paths and bring Naomi and Dad together at Dodi's recommendation. I guess that would be however as determined by Ms. Viola in conjunction with what she thinks is in Naomi's best interest and when Dad is ready. If I recall correctly, that's how I would envision how that would look.
Ultimately,
I think Dr. Cushley put a 6-week mark on it. I suppose it could take longer. I suppose perhaps it could be shorter. I don't know.
One thing that was said, I was here during the criminal proceedings, the appellate attorney misspoke on the issue as to whether the process had already begun with Ms. Viola.
Okay.
And I don't remember whether it was 3 or 4 sessions that my clients indicated that it was 5 sessions. But there are a number of sessions that have already taken place with Ms. Viola.
Oh, at the jail?
And he started the process before he went into jail because
Okay.
we anticipated, as we'd already had her view of what should happen and so forth. Has Ms. Viola been in the jail yet?
All right.
I have spoken with Ms. Viola and asked her to, and we actually checked with the jail administrator to find out what the process would be, and then we sort of connected the two and stepped back. So my understanding is that I agree with what others have said, that she's willing to go. We got from the jail the process that she needs to go through, which is basically background. I talked with that process was being initiated and underway. So that should hopefully happen very quickly, that the process is resumed. But there were a number of sessions that were already underway.
Were those like a year ago though?
Yeah.
All right.
So my suggestion is that we leave it up to Ms. Viola whether she needs to start over or
Sure.
whether it can pick up midstream somehow.
Okay.
And that she be left with some amount of discretion as to when to integrate the child, because there was some work that needed to be done before Naomi was integrated into the process. As to the substance abuse issue, I think that the court has heard extensive testimony about my client's substance abuse and problems or lack thereof. I think the testimony was pretty clear previously that my client maintained a substance abuse-free home for a substantial time before this family came to the attention of the court. The report itself from the substance abuse assessor was admitted at the time of the first dispositional hearing and does not indicate a current need for treatment. And so I'm not opposed to keeping an eye on that situation once my client's released, but I don't think that there is a need for substance abuse treatment, and I think that focusing on the treatment that was recommended is a better plan. I had intended to talk about counseling. I think Mr. Albert has already covered that. So other than that, Your Honor, this plan seems to incorporate fairly well the recommendations of Dr. Kushler. So I think we're satisfied with the general direction of that.
All right. So just so that I want to make sure that the court's clear. So there's the Dodi Viola piece, and then respondent father is going to be engaging in individual therapy with Dr. Kushler, when that can happen. And then is also engaging in the DBT therapy with Ms. Ward.
Well, I don't think it was...
Those are the three pieces here?
I think there were two pieces. So I don't think that Dr. Kushler anticipated both the need for the DBT and therapy with her. She was willing to, after she had testified, she was willing to provide the ongoing counseling needs that she identified herself. I've had several conversations with her. She's indicated that the reason that Ms. Ward was recommended by her was because at the time that she did the assessment, she was anticipating the need to testify, and she was not willing to provide counseling in a case where she was going to be called upon to testify. So I think we have the two pieces.
So tell me that again, what the two pieces are. What your understanding is.
DBT therapy with either or Dr. Kushler or Ms. Ward is one component, and the other component is Dodi Viola's beautification therapy.
We would agree, we believe Ms. Ward is the best person at this time to provide both individual therapy and the counseling agencies prepared to pay for that in the form of sole.
All right, so that's going to be individual and DBT therapy with Ms. Ward.
As far as substance abuse treatment goes at this time, we have no exceptions to Craig's recommendation. We don't believe that's a major issue now. We believe screening will probably occur through employment and through the probation department. If that becomes an issue, we'll readdress it at a later date.
Okay.
Your Honor, this is Mrs. Warner.
Okay, go ahead.
Mr. Cardoff had been to possibly having your father of bail system. I don't know how much more we can do with that. I would just point out, my bail by now, everybody hoped it was going to be kind of an easy transition because she sees him every day on a television screen at her house when he's reading the books to her. So she obviously knows him and goes for him and knows his him, but she needs to find out now he's a real person, we all thought, because he can interact with her now instead of just reading a book and not being able to talk, free talking. But that was one option, and I think that as for the jail,
Ms. Warner, you were breaking up. We didn't really hear anything that you said in the first part of your sentences.
Oh, okay. Mr. Garda has getting the jail, the available.
No, still breaking up.
I don't know what, let me get off the speaker. Can you hear me now?
Okay, go ahead.
Okay. Mr. Gardoff was looking into seeing whether or not the jail video system could be integrated into the introduction for Naomi to her father, because all she's seen him on is obviously every day a television screen reading the stories to her. And to have him interact with her would be to show her that she was, this is real, he's there, he can converse with you, but that would be one method by which the reintroduction of Naomi to her father, or the introduction of Naomi to her father live could happen. And the second thing I would think that the jail would need from you is a order that all that's going on in this case and the treatment plan is at the discretion of the sheriff.
So what do you mean? The treatment's what do you mean, what's at the discretion of the sheriff?
What he will allow in his jail for the therapy and visits with the child.
All right, does anyone want to, so do the parties want to speak to whether reunification should occur at the jail?
Well, Your Honor, we don't believe that it's going to be possible for reunification to occur at the jail. I don't know if we're not comfortable with parenting time occurring at the jail. I think we've stated that position before. We will follow this court's orders and directions, and however we're directed to arrange it, we will. I would call it parenting time to be a reunification. It's parenting time. We certainly believe at some point Mr. Burns seems to be making progress and has indicated a willingness to participate in all of the programming. We believe at this point probably the best step is to get Ms. Viola and Ms. Ward involved and perhaps return for a recommendation from them out when some type of reintroduction of Mr. Burns into Naomi's life should occur. I don't know if there's any video in the jail available. I don't think that would necessarily be appropriate, but I guess I would leave that to the court's discretion. Certainly not comfortable with her going to the jail to do the visits. I don't believe the agency is. I believe we've been consistent and voiced that opinion in the past.
If I may be heard, Mrs. Warner, it's actually in their policy manual that they're supposed to facilitate parenting time for incarcerated parents, so at the facilities. So I assume that as a department policy for the whole state, that would be followed and could be used in this case.
If I may, on that issue, Your Honor.
Sure.
I'm a little confused by the statements of Mr. Eldred in that I don't think that a further court hearing is necessary. When we incorporate the recommendations here and we start the process with Ms. Viola, the process itself anticipates that she will start with sessions with my client and then integrate the child when her professional judgment is the appropriate time. You can't see us putting a hurdle in there of scheduling some kind of a court hearing or a review hearing in order to accommodate that. We're going down the road of reunification. And the court has already deemed that it's in the best interest of Naomi to do that. So it seems to me that we just need to move the process forward. Now, the issue that Ms. Warner raised is an excellent point, in that the jail has allowed, because they do have video equipment, has allowed some visitation to occur over a video screen with my client and his wife, and perhaps other family members. I don't know yet. Have there been other family members? There have been. And so it seems to me that at Ms. Viola's discretion, that may be an appropriate tool, and we should enable that if the jail is willing to accommodate that, which apparently they are. Maybe we should put the person who is kind of lead us through the process in charge of deciding when that is appropriate and how that's appropriate. But it makes perfect sense for a child whose exposure to her dad has been by recorded videos.
All right, 1 second. All right, sorry, Mr. Conker, go ahead.
Well, I wouldn't presume to tell Ms. Viola how to do her job, but it makes perfect sense for a child whose exposure to her dad over the last many months has been through watching pre-recorded videos, to see him on the screen and so forth, and that may be a tool that would be very helpful to Ms. Viola in accomplishing the end goal of reunification here. So I would ask the court just to incorporate that to the extent that the jail will allow, at the discretion of Ms. Viola, video conferencing can be employed to achieve the goal of reunification.
Is there any objection to video conferencing if that's the initial plan?
If Ms. Viola's comfortable, I believe we'd be comfortable.
All right. Any objection, Mr.
I
Gartoff?
have no objection to allowing Ms. Viola to do her job and to facilitate reintegrating Naomi with the responding father as she sees fit in her professional opinion. So if Ms. Viola wants to do that face-to-face, okay. If she wants to do it via video, fine. But it's Ms. Viola who's going to make that determination.
We seem to be on the same page.
Should be more with it. All right. All right, anything else?
No, ma'am. Oh, yeah.
All right, so the court will adopt the parent agency treatment plan. Let's see here. I do find that the lawyer guardian ad litem has complied with the requirements of the statute. Notice of today's continued dispositional hearing was served as required by law. Since the last hearing, the child has been in the care and custody of the non-respondent mother. Court has considered case service plan and other evidence presented, and the court's findings are based on this hearing and exhibits 1 through 3 admitted today. Naomi will be continued in the protective temporary custody of this court, remain in the home, released to her mother, who has consented to comply with the parent agency treatment plan and service agreement as it pertains to her, to work towards reunification with respondent father under the supervision of the Department of Health and Human Services. It will order the respondent father and the non-respondent mother to comply with and benefit from the case service plan, which shall include that the respondent father sign all releases of information. Mrs. Burns, if you could notify the Department of Health and Human Services of any plans for extended travel out of state with Naomi. If you shall, respondent father shall notify the Department of Health and Human Services of any out-of-state travel. The department has the discretion to request the respondent father to provide random drug and alcohol testing if they think it necessary and appropriate. The Department of Health and Human Services shall provide for and pay for all services as outlined in the parent agency treatment plan. Parenting time. So I will adopt the parent agency plan, specifically that the respondent father shall complete and demonstrate benefit from individual as well as DBT therapy as referred by the Department of Health and Human Services. The DBT shall be a minimum of 26 weeks with a qualified clinician who is trained and certified in that area. I'm going to ask non-respondent mother, Mrs. Burns, to complete and provide a safety plan to the department in preparation for the plan and the goal of reunification, and that the non-respondent mother, Mrs. Burns, and Naomi shall engage in reunification with Dodi Viola as directed by her. So I'm going to ask Mrs. Burns to contact and schedule those appointments within 5 days. Okay, just get those scheduled. I don't know what Ms. Viola's schedule will look like, but if you could get on her calendar within the next 5 days. Parenting time, I want to address parenting time of Joshua Burns is supervised until further order of the court by Dodi Viola. The manner and frequency of parenting time in a therapeutic setting as directed by Ms. Viola. And parties are telling me if that includes at the Livingston County Jail, there's no objection to that.
Ms. Viola recommends that we don't object.
Agreed.
That'd be my position as well here.
All right.
We certainly ask for the order the agency once again to pay for those services.
I will include specifically in the order that DHHS shall provide and pay for all services outlined in the parent agency treatment plan. And part of this court's order. So maybe I ordered them and they're not in the plan. All right. Does that cover it?
A couple of things, Your Honor. First, I apologize. It wasn't clear to me who you had ordered to produce the safety plan.
That's to be Mrs. Burns.
Okay. And the second thing in regards to...
And I don't know if Ms. Viola can assist her with that, or maybe that can be in conjunction in working with Mrs. Viola.
Okay, thank you.
Okay, what else?
In regards to the supervised parenting time scheme with Ms. Viola, I understand manner and frequency are within her discretion and so forth, and that if there was personal face-to-face contact until further court, Dodi Viola would be supervising. If there was, in her discretion, a benefit to video conferencing, would Ms. Viola need to supervise a video conference, or at the point where that was utilized?
This is supervised parenting time.
Okay.
So with the order reflect to be supervised by Ms. Viola. So if that's video conferencing, that has to be supervised, and that has to be supervised by Dodi Viola.
All right, thank you.
Okay? We'll go ahead and schedule this for a 90-day review. It's 90 days from now? Monday, usually Monday afternoon. Is that 90 days? Within 90 days from now? would be like December, it either has to be November 31st, I think, to be required. Or November 30th. How's November 30th at 1:30?
It's fine, Your Honor.
Very good, Your Honor.
That's the Monday after Thanksgiving.
Is it?
Yeah, it's kind of tight. Since we're traveling by car back from Texas.
Free on December 7th and December 14th, Your Honor, if you're looking at Mondays.
I don't know that we can go out to December. It's December 7th. It's going to be outside 90 days.
Does the court have November 23 open?
Do I have November 23rd?
Yep. I'm asking that 1:30.
November 23rd. Any conflicts with that date?
No, Your Honor.
What time is the court?
1:30.
1:30? That'll work.
Okay.
I'm available on December 23rd now.
November?
November 23rd?
November 23rd.
Okay.
Get the right one.
All right, November 23rd at 1:30. All right, Ms. Warner, I will not allow your appearance by telephone.
Yes, I can
It's not
understand
typically
that.
my practice. For further review hearings, ongoing hearings, you'll need to be present or request an adjournment as provided by the court rules.
I understand.
Okay. Okay.
Thank you, Your
That was
Honor.
it. All right, we'll see you at the end of November.
Goodbye.
I had like my... In which it would have been with the other note. No, it was in type and printed. I did see a typed thing, but it was also between the note. Yeah, but it would have been on. Okay. Then that would have been my, these would have been my notes. Okay.